Admittedly, the break was a short one. Nevertheless, I'm glad to find you back in the room. Our next session is titled The Promises of External Processing Between Assumptions, Possibilities, and Practicalities. And I was already a few times approached in the breaks before. Apparently it is on many people's minds in the audience. Probably there's not many other issues that are so hotly debated currently. While proponents of processing, external processing, are looking into this as a way to deter, reduce irregular migrants, opponents point to strong legal, practical, and moral challenges. In this panel, we try to approach it, let's say, beyond ideological blinders, let's say it, and we try to look from a political, legal, practical perspective and hopefully, probably find also some common grounds on this very divisive issue. My name is Martin Wagner. I'm Senior Policy Advisor at ICMPD, and I have the honor to moderate this panel. And I have a wonderful panel here with me, three not only very knowledgeable, but also very passionate panelists. Henrik Ankerstjerne, Deputy Permanent Secretary, Minister of Immigration and Integration of Denmark. Woollard, Director of the European Council on Refugees and Exiles, ECRE. And Thym, Chair of Public European International Law, Department of Law, University of Konstanz. Now, before we will get to the panel, I would like to invite you, and you saw this already, we have a QR code here, and I would like to invite you to take your mobile phones and take the QR code. And please let us know what comes to your mind when you hear or think about external processing. What is immediately that comes to your mind? So far not, okay, safe third country. Wow, that's a lot. Wonderful. Before we try to detangle some of these still in-popping words or characteristics that are on your minds when you think about external processing, just a few looking back. External processing is not new at all. We will come back to this several numbers, but external processing is actually popping up quite long ago already. It gained much prominence basically in 2015 and 16, I would say, with the large arrival of people and the thought how to address things differently. And then there was this, I would say, one major development came for sure with the EU-Turkey statement, which was the first, let's say, in this direction of external processing, although it has another nuance there. We saw then later on discussions around 2018 about control centers, disembarkation platforms. All did not very much continue. EU policymakers at that time looked very much as the Australian Pacific solution, so how Australia dealt with mainly people who come via boats to Australia. But then I would say in 22, 23 it geared up a lot, the discussion, with Denmark and UK very much bringing Rwanda, or the Rwanda possibility of external processing in Rwanda. And this was very recently, as you for sure heard, followed by Italy, with a similar concept with Albania, but it has some nuances to the one in Rwanda. And at the same time, there was also a huge back and forth or exchange of letters. We had the letters of 15 member states, that was in May 2024, to address to the Commissioner Johansson, to asking to further thinking out of the box. There was a joint statement, this was countered more or less by a joint statement of 100 civil society organizations raising concerns that the future EU must uphold the right to asylum in Europe. From July 24 this was. Recently we had the letter by the President of the European Commission, von der Leyen, also touched upon external processing in one or the other words, and we very recently had a letter by the 17 member states towards the Commission, which brought an additional element in there, also with return hubs, which is again a bit distinguishing. Now, we have many keywords here on our display. I told a bit about the background, and I would now probably ask Daniel to help us navigate a bit through all this, not through all these terms, but through some of them I would ask. Also because I believe with external processing we very often speak also different languages when we communicate. So I would probably ask Daniel to help us here to detangle a bit this notion. And yeah, the floor is yours, please.
Yeah, thanks also for having me. I mean, the sheer number of words shows us what I have experienced on previous occasions. There tends to be quite some confusion. So it can be useful as a starting point to distinguish two different models, how external processing can be organized. Safe third country, or Rwanda, is the first model, and the second one is what I would call external or extraterritorial asylum procedures, or Albania. So what are the differences? Safe-third countries, or Rwanda, it's about people who arrive in Europe and who apply for asylum, and they are then transferred to a safe third country where they receive an asylum procedure by the domestic authorities of this third state in accordance with its national law. If they receive a protection status, they stay in the safe third country, Rwanda, for example, permanently. They are not transferred to the EU, and the concept is well established in theory. There has always been a provision on safe third countries in the asylum procedures, regulation and directive of the EU, but it has hardly ever been applied in practice, and the political rationale brings us back to two words on the screen. It's expensive and costly, or costs a lot of money, was another term, waste of money. And the political rationale is not that you transfer tens of thousands of people, but that it is enough to transfer, let's say, a few hundred or a few thousand, and that doing so will have a deterrent effect with less people arriving. So that's the safe third country model. The other one is what I would call extraterritorial asylum procedure. And there it's EU member state doing an asylum procedure in accordance with European law and their national laws on the territory of a third state, such as Italy plans to do in Albania. And if the outcome is a positive decision, if there is a need for protection, the person is transferred back to the member state to reside there permanently. Legally, that's not currently possible under EU law because asylum procedures have to take place in Europe. Italy can do it nonetheless because it's only people rescued on the high seas which are brought to Albania, and EU law only starts applying once the people have reached European territory. There is then a third model which receives a lot of attention at the moment, but it's really different. It's the famous return hubs. The idea of return hubs is that you complete the asylum procedure on European soil, a regular asylum procedure. So you do not return asylum applicants, but only people where you know already that they do not have protection needs, and the idea is again that this reduces the number of arrivals. And if I may, there are, I think, if you address external processing, so safe third country and Albania from an abstract perspective, at least 4 challenges and hurdles which politicians should be aware of, because we also read a lot about risky and problematic wishful thinking. I think these 4 hurdles are the main ones to consider in any discussion. The first one is a straightforward one, it's diplomacy. You need to find a third state willing to cooperate. The second hurdle is practical. You need to guarantee reliable asylum processes in a third state. We just heard that Egypt is only just adopting a law, so in many countries in the global south, there is no functioning asylum system, and that the British government learned last November when the Supreme Court stopped the Rwanda plan because the government hadn't convinced the court that the Rwandan asylum system was reliable enough. So the first challenge is diplomatic, the second one is practical, the third challenge is legal. As you may know, EU asylum legislation currently requires a connection between the applicant and a safe third country. So you cannot send someone to a safe third country where that person hasn't stayed previously. I'm personally convinced that this is not mandatory under international law, so it could be abandoned. And that's a political debate which might surface very soon, because the Commission has been tasked as an integral part of the new pact to adopt a report next summer whether to discontinue the connection criterion. So that is an example of a legal challenge. Another example of a legal challenge is the recent decision by a court in Rome that Italy has to bring 12 people back to Italy, which has been transferred to Albania. That is, for all I understand, primarily an issue of domestic law, because the border procedure can only apply to certain categories of people. That would change if the EU agreed that the pact was brought forward and that the new asylum procedure regulation could be applied fairly soon. Then Italy could restart its operation fairly soon. So that's an example of legal difficulties. And finally, an element which is often ignored in the European debate, it's what I would call a procedural difficulty or hurdle, because before you bring someone to a safe third country, you have to perform an admissibility procedure on European soil, including a legal remedy. Such a procedure often takes time, weeks, if not months, and the whole idea of a deterrent effect evaporates if you need several months before you can transfer an asylum applicant to a safe third country. So that's a procedural element the domestic homework states would have to do if they wanted to operate such a scheme.
Wonderful. That was really a fast run through different types. When we speak about external processing a bit further, you already alluded to some of further types, and then also came directly in with the challenges and practicalities and legal obstacles. Henrik, Denmark was always at the forefront when it comes to external processing. I think it dates even before the 90s that you already had the notion of safe third countries in your laws, if I remember correctly. So what is the main rationale and objective or expectation behind Denmark's interest in this in external processing? Can you please?
Yes, I mean, you're asking me to give everybody an insight into 55 years of history in Denmark, and I'll try to do it very briefly. Well, we were among the countries first signing up to the convention. I think even the convention was drafted by a Danish civil servant, the first version at least. I think his name was Olsen. So I feel a little bit attached to the convention because I know it has a Danish sort of origin, and it has, of course, to do with also the very strong Jewish lobby after the Second World War, trying to ensure that this would never happen again. So it all has a background and a solid foundation that is being supported by everybody in Denmark. It's like a very, very tiny minority that does not want the Refugee Convention to exist and to be applied. So that's the starting point. The second point was that very early on, the politicians identified the real issue with the present international system, and that is that the convention is made for direct flight. That means from your country of origin to your first country of claiming asylum. That's what the convention is all about. And most of the movements we see to Europe are of a secondary nature. So it implies that people have been staying for a while in the first countries of asylum. I'm not saying they're having a perfect life there, but they move on from there. These are not reasons of persecution in most cases. These are reasons of all other good, you can say, causes that have to do with economy and family, and there are many interesting, you can say, reasons for this, but this was never really researched, I think, and I really think that the Danes did it very early on, and that's why the idea started popping up of, first of all, inventing a safe third country principle. I think it was Denmark were among the first countries to apply that principle. It was later on agreed internationally that it does exist, and even in EXCOM conclusions, I think you can make references to this concept, and it later on then ended up in EU law. There was actually never a link intended by the lawmakers. I know this because I was in the room when we agreed to the text that is right now in the Procedures Directive. It was actually a grandfather clause because I believe it was Sweden and maybe a few other countries had already a link in their national legislation and didn't want it to be overruled by a future EU legislation. So they were allowed to keep that link while everybody went on with other developments. But the court found it ambiguous and then twisted it all around. So now there's a link and everybody's surprised about that. But Denmark doesn't have the link. Of course, it's not a legal obligation according to international law. You just said that, Daniel, and it's completely correct. UNHCR has confirmed it in a legal note from 2017-18. And this was on the basis of which we started the whole process. I'll just jump now from the, you can say, the need for having some sort of an instrument to prevent the secondary movements, and then move up until to the date of my prime minister, present prime minister, when she started in a minority government, and she was completely convinced that this was never tried. This idea of setting up a system of transferring people to a third country was never really tried. It was just talk. Nobody really did a thing about it. And she was quite well informed by, I think, former staff of UNHCR. So she was among the prime ministers I've had who was really, really well into the issue. And so we were just ordered to figure it out. And we started with a paper looking like this, nothing on it. And we slowly tried to identify the issue and how we should come around it. And we agreed that a legal, very thorough analysis was needed. So we spent the first 6 months. Of course, these are 4 or 5 tracks moving parallelly, but one track was a legal small unit of 3 or 4 very strong lawyers working with our best lawyers in justice and foreign affairs and everything from public law into private law to international law. All the expertise was in the room, and it took us about 6 months, 50, 60-page document going through Danish law, international law, EU law, and the combination of these 3 regimes. And after that, we felt quite confident about exactly what we could and what we could not recommend. And it was later published. And for instance, it also concluded that the Danish national legislation even had a requirement of a link, but it was like a subtle reference to some question asked in Parliament. So we had to change law initially, but we did it in a very clever way, I think, namely because of the legal analysis pointing in the direction that you cannot have a transfer system without a treaty obligation on both parties. And this is the first mistake that was done by UK. There was only an MOU. And if there's only an MOU, you make the system quite vulnerable. The courts will not feel comfortable that a police officer is bound by an MOU. He will be bound by a treaty obligation because the treaty will have to be implemented in national law. So this was the first requirement we put into the legal assessment. And then if you listen to Daniel, he just put the recipe. So how do you go about it? Well, first step is to do the visitation. Who goes, who stays? And the first visitation, of course, you have to look at Article 3 cases, pregnant, very sick, very old. They have to be excluded from the transfer. Then you look at Article 8, everybody with a family link not being able to exercise its family life and private life, out with those. Then you have all the Dublin cases. Does it make sense to put one person from Denmark and put them in Rwanda if you can readmit them to maybe Germany? So you end up with a residual caseload where you are quite sure that this caseload will not qualify under any human rights obligations. And then you set in motion a very fast system. I'm talking about what we normally do in Dublin cases, so 2 level, 1 appeal only. That's our system Denmark. We have 1 appeal, 1 decision. So it's very fast. We can do fast tracking in less than a week, 2 levels. And so this is the, we basically draw it up. We drew it up in a process like a stream model and put it up to the top levels at the Prime Minister's office, and it was agreed at the end that this is a model they wanted to pursue. They wanted us originally to do the processing in a third country. You also mentioned this type of model, and we looked into it very, very carefully, and if you do that, you have jurisdiction. This is the big buzzword. You have to really look into the word of jurisdiction, because the moment you have jurisdiction in Rwanda or in another third country, you have a discrimination issue. You have to provide exactly the same services there as you provide at home. How on earth will you do this if you, in your reception system, give access to a labor market, or you give access to social health services of a certain nature, maybe activities, non-paid activities and social services for kids. It's just like a nightmare. I mean, I'm telling you, don't go down that road. You will never solve it. So we didn't want to make a model like that. This was the Prime Minister's best wish, but she held back and said, okay, let's move the other model. And so that's what happens is basically when you step upon the plane, the person is in your custody, but it's still now the captain basically controlling the ship. So if the captain says, take the person off, you take the person off. So you're in like a limbo of a jurisdiction until you reach the safe third country, and as soon as the authorities take over, physically take over, then your jurisdiction stops for certain. And that was the trick here. And after that, of course, people are asking always, how do you make sure that there's no refoulement at the other end? And we knew the system in Rwanda was quite fragile. It was quite newly established. They had not had individual case assessment before. They did group determination, which many African states do under the convention of the African OAU convention. So we had actually suggested that we do a capacity building project for a while. This was also missing with the UK model. And finally, we wanted a monitoring system, and we wanted to put in the Danish ombudsman. So this was the setup, and this is, I truly believe it could have worked. We were told not to do it, but we could have made it, yeah.
Touched upon many things, many issues. I appreciated very much this, also how it developed, that you also saw something is not working in the asylum system at the moment and how we could fix it. Also interesting your observations with regard to the background, the treaty instead of a MOU, and of course the practicalities that you mentioned now at the end. Catherine, naturally I guess you see it differently. ECRA is an alliance of 125 civil society organizations. Has been quite vocal, mentioning concerns about external processing models. Could you walk us through some of the concerns that you see? I think some of them are probably also there, I see, but,
yes.
Please.
This could be a summary of what I'm about to say, but thank you for the invitation, first of all, to this, I think, timely but somehow perpetual discussion. From ECRE's perspective, we see obstacles to external processing, and I'm going to concentrate on external processing of asylum applications, because as has been said, there's so many different models here. Where relevant to the safe third country concept, I'll perhaps add that in or come back afterwards. The obstacles that we see can be divided into three categories: legal, political, practical. I'm going to take each in turn. To give a spoiler alert from the beginning, in our view, these obstacles are insurmountable. If we look first of all at the legal obstacles to external processing, so external processing of asylum applications is not forbidden per se by international law, a point already mentioned, but there are only certain circumstances in which it could be legally possible. More likely and more often, these arrangements involve breaches of international law, EU law, national law, depending on the context. Very often that would be Article 31 of the Refugee Convention, because they involve penalisation based on manner of entry, and the much abused Article 31 is then breached. There may be also other kinds of breaches of international law of the sea, for instance, if people are taken to a particular destination rather than another. Those models may be used to justify denial of territorial asylum, which in itself is unlawful. Quite often we see these arrangements designed to be non-justiciable, so designed to avoid judicial review because states fear that judges will kick them out. That in itself is an erosion of the rule of law. But the most important legal obstacles to external processing of asylum applications by Europe are the fact that the required legal standards cannot generally be met in an external processing centre. So we're talking about procedural guarantees, access to legal assistance, effective remedy, non-automatic use of detention, and so on, which are not special luxuries for asylum applicants. Those are essential parts of any legal process. Unfortunately, we could say that for many European states, respect for international law may not be their primary concern. And in practice, it's the political obstacles that have often led to these kind of proposals, these perpetual proposals of external processing. The political obstacles lead them to fail. So other countries don't accept the presence of external processing centres, despite pressure, threats, bribery, and so on. And the reasons for that, I think we've heard during this day, that in many cases they're countries that are doing far more than most European countries when it comes to offering protection. People also get stuck in those countries. That's not a risk, that's a certainty. And in all of these models where some form of this has been tried, that has happened. But these deals can also have a corrupting impact on local politics, but I think it also has a corrupting impact on our own foreign policy, which becomes about migration control rather than anything else. And let me conclude with the final obstacles, which are the practical ones. The cost is often ruinous. Italy will pay €1 billion for the Albania deal. The UK has already paid more for the Rwanda deal, even though nobody's gone to Rwanda. States can demand what they want because of Europe's desperation on this issue. Other practical concerns may be the attraction of smugglers and traffickers because the problem of deportation back to countries remains. And there may be a counterproductive impact in terms of gelling the development of protection systems. I think this is also relevant to the safe third country concept. That countries don't necessarily have an incentive to build up a protection system if that may be become part of the debate on Europe outsourcing responsibility. So I'll leave it there.
Thanks a lot. Also here, quite a number of points raised. Many we saw indeed on the screen by you. Spoke now a bit like what divides us, what divides the positions, and what is external processing. In the second round, we would probably like to try to find probably commonalities also that are probably overlapping or where you can find each other. In introducing this second round, I would again ask you to take your mobile phones and tell us your view, because there can be different outcomes of external processing, and some options we put here. So in your view, the most likely outcome of external processing models would be, and we offer you here a few options, and please choose only one that you think is the most likely one. So reducing irregular migration, putting the right to protection at risk, reducing deaths of migrants en route, shifting responsibility to other countries, expanding protection spaces for those who need it. What would you say is the most likely outcome? Okay, there are two front runners. This is putting the right to protection at risk and shifting responsibility to other countries. Yeah, these two, I think, are trying to match for the first place. Actually, a nice segue to you, Beck, because recently, the UN High Commissioner for Refugees, Filippo Grandi, voiced in an article for The Guardian from August 24 criticism on the Rwanda approach, but would speak a bit about the main issues here on the table. But he also, at the same time, alluded to a proposal in which the most heinous asylum claims would be processed regionally in safe third countries, while the most complex and credible asylum cases would be heard in EU countries. Now, do you see this as a plausible suggestion? Is this something that you could find some opening space for commonalities?
Well, it's, I don't know how to say it, it's not a legal position, because the UNHCR legal position is that the safe third country model is legal and can be applied. So now he's basically reducing our legal space. So I don't know if that's a compromise that I could accept. I basically think it's wrong, legally speaking. So if it's not law, then it has to be policy. And if it's policy, I can only agree if it makes, you can say, sense in both legal terms, but also in a Danish European context. And I don't think it makes sense, actually. Why should Europe do away with one important tool that is a legal tool? Why should we go above conventions? I don't get it. For me, it's a bit weird. The other argument, I think, that we can, as long as we do it in Europe, it's better than doing it in Africa. I really don't like the connotations of that statement, because we are doing it in Africa. ETM is in Africa. UNHCR is running ETM in Africa, in Rwanda. So I don't get it. So it works for people who come from Libya, but not from England. I don't get the point. There's something. It's not a nice sound in my ears, to be honest. So I'm not in line with that statement. I think we should go back to what is legally possible and then do that as a starting point. And I think one should really do some research into why are people moving from their first countries of asylum, and who are actually arriving on our shores. Are they secondary movements or are they primary movements? Look at the Ukrainians. When they arrive, 6 million people, they all go in, they all are greeted. It creates almost no turmoil, except, of course, countries like Poland and Czech and the small Baltic nations are really hard hit. But I would say if this was secondary movement coming from elsewhere, like in 15-16, it would be a catastrophe for Europe. So it's very important to distinguish between the secondary movements and the primary movements. I think this is where research is missing. And if we only knew, I can tell you, we did once a very quick, small assessment. And out of 100 asylum seekers arriving in Denmark, none came from a first country of asylum. None came from a country of origin. Only 1 or 2 cases came from a first country of asylum that was not safe. Everybody else came secondarily for other reasons than protection. So, I mean, I kept this in the cupboard for about 8 years. I don't know what it looks like today. But what I can see is that the system attracts 70% or 65% of people who do not apply for asylum, who do not qualify for asylum. So that's around 600,000 every year. That's the size of the second biggest city in Denmark. Yeah.
So just we wanted to have about commonalities. So I still wanted to ask you about this one.
Yeah, let's start with the
where
law.
do you see the commonalities where you can
Let's
bring
agree
also
on international law.
UNHCR
Let's agree on
and civil society organizations?
Let's agree on that. Let's agree on international standards. We're not operating in a vacuum. We're operating within a legal system in Denmark, and we have to, of course, obey to all the requirements of our laws and international laws. So there will be very clever judges looking into every single case. And I think maybe UNHCR should accept the fact that our courts are independent, they're competent, they're clever people, they take every important issue into consideration. Lawyers are appointed, blah, blah. So let's just be within the conventions, and let's have confidence in our courts. I think that would be my compromise.
Thank you. The same question to you, Catherine. Where are commonalities? Where do you see?
Yeah, so I think from our perspective, as I already mentioned, anything that is external processing of a full asylum application, we consider out of the question because of the obstacles mentioned. But there are things already going on, and situations where there is some limited form of processing in relation to international protection needs that may be taking place externally. So there may be some possibilities of common ground. So preliminary assessments of protection needs. To give an example, that may be in a context of securing safe routes to protection. And we did a recent study on safe routes to Europe for those in need of international protection, beyond the resettlement piece, which we're all familiar with, but other channels. Most European states have these channels in law. The trouble is it's so little used, the numbers are tiny, but still that's a very important need. This is preliminary assessment in order to grant humanitarian visas, for instance. Preliminary assessments before evacuation. That may be emergency evacuation, it may be immediate evacuation of people suffering from torture at that minute. So there are some elements, let's say. I think at the same time, any discussion of these centres has to somehow avoid, let's say, naivety about what are the intentions of European states here. There is a push to find ways to deny access to protection for those who are arriving at the borders. And that is the context of our discussion. Rightly or wrongly, that is what states are trying to do. So many of the proposals, I think, about routes-based approaches, for instance, need to be examined to see whether or not there is some complicity in that agenda. Overall, maybe it's a bit going in a slightly different direction, but there is much better value for money to be had by investing in efficient asylum systems in Europe. We heard the discussion this morning about the new moment that would allow better implementation of EU asylum law, a return to compliance after a number of years where compliance has been neglected. And as a final point, I don't think that should be a separate debate from the labour question, which very rightly ICMPD has also put on the agenda today and tomorrow. European countries are trying to ride two horses at the moment. On the one hand, they are ever harsher and more violent towards people arriving at the borders to seek protection, trying to force out that group of people, while at the same time desperately trying to bring in other groups of people in order to respond to labour market needs. And genuinely innovative solution would be to try to put those two pieces together, as we did in the case of Ukraine, rapid access to protection status, rapid access to labour market, and not do these two paradoxical things at the same time.
Wonderful, thank you.
I have one comment. I forgot to say it before, but I think it's very important. We're talking about transfer of asylum seekers to safe third countries without looking at a broader context. When we talked about it and when the policy was pursued in Denmark back from 18 till today, of course, this is just one single little element of a whole range of investments you have to make. You have to go to the countries of origin. You have to go to first countries of asylum. I think Ruben Menikvela was very, very clear. We are not giving enough money to the first countries of asylum. They are hosting enormous amounts of people, and we feel very much alone, I must say. We are among the 5-6 countries in this room paying our share, like 3 times more than everybody else. And so get your hands in your pockets and let's go there. Another issue is resettlement. We all do resettlement, and we've been doing it for a long time, but we can't do irregular migration and resettlement at the same time. We have to get the numbers down. It's 1 million a year for 2 years in a row. This year, a little bit down. But it's just too much for Europe. It's 600,000 people coming here with a lot of aspiration, a lot of hope. And how do they end up in an irregular situation, living in the streets? What misery we are offering people? And it's really not a dignified model that we are operating at the moment. So we have to bring the numbers down. And but I also want to say that when we offer something to a third country, we can't dictate, here is my burden. So the first question, the first one is putting the responsibility to other countries. They can just say no. I'm not I'm not Napoleon. I don't want to conquer the world. We can give a good offer, and in that offer will always be a neutralization of a burden. So always be, you take one, we take at least one. So with Turkey, it was we take 45,000, you take 200. So that was a pretty good deal for Turkey. But I think with Rwanda also, we're ready to do a lot of resettlement out of Rwanda, and so it will always be a burden sharing exercise. And those who do not understand this will just have to sit in the room and negotiate a deal like this for 2 seconds. So I think this point is so important, and I just needed to get to the room. Yeah, sorry.
Thanks for this addition. I think brings us also to Daniel, probably to bring you back in. We heard now international law as a framework where we find commonalities, also parts of the procedure, not really the asylum procedure, but some steps there. We also heard actually from both Ukraine as an example of thinking. What did you hear about commonalities and possibilities?
I'm a bit surprised that there might even be room for a common ground. And I think the secret is not to focus solely on whether we do a safe third country scheme or not, but to broaden the perspective. Because what you two just said was adopting a broader perspective. And there might be room for a common ground if we focus in a first step on the deficits of the current system, because I think we can agree quite easily that the deaths in the Mediterranean are not good. That it's not good that we have very dangerous travel routes, which mean that poor people, very vulnerable people, and also very few women actually make it to Europe because it's so dangerous to travel. We might also agree that the real-life alternative of paying the Libyans and the Tunisians to prevent the people from coming to Europe is also not ideal. We might also agree that we have a deficit in the current system because returnees de facto stay in Europe. That's also a problem, probably from the perspective of EU asylum law. And we might agree that all these irregular arrivals create a sense of less of control, which is politically toxic. So if we can, at a very abstract level, agree on these deficits, there might be room to find a solution which includes safe third country arrangements, but which from a broader perspective address all of them, and that is, well, the rules-based approach about which we spoke already. So what would it mean? It means enhancing protection capacities in countries of transit first arrival. It means addressing irregular movements. That means we have to find solutions for people without protection needs that can be voluntary return to countries of origin from transit countries, because they realize if they move on to Europe, they might end up in Rwanda or in Uganda or in a return hub elsewhere. So there can be a room to use them in a clever manner. That would also include legal pathways. But even if we could agree, possibly at a very abstract level, that is what we might want to achieve, I think it all boils down to what we are still seeing on the screen here. What is for the audience the second most popular answer? It's the shifting responsibility to other countries that I think that I interpret in a way that most of the people here in the room interpret the current political scenario to mean that any move towards safe third country would not result into such a broader landscape, including legal pathways, but that they would essentially be building blocks of closing Europe off. But I think, what is the real-life alternative? I mean, that would be my questions to people who say that cannot be part of the solution. My interpretation of the political status quo is that the political support for the right to asylum is diminishing across Europe, so we really have to offer alternatives which uphold protection credentials and which also give politicians an instrument to signal to the population that they are regaining control. And since safe third country schemes are so popular, or extraterritorial processing, they can be a very powerful communicative tool, and I would personally be willing to at least try it.
Wonderful, thank you. Again, many points, even more thankful. We have still time. I could not imagine that it would be possible. So we can nicely get 2 to 3 questions, and I'm okay, good. I mentioned 2 to 3 questions, but yeah, let's start please here. Was the first one, then here, and then yeah.
Hello, Viet Novotny again from the Martin Center. I have a question to the Danish Deputy Minister, please. You mentioned that the Rwanda scheme would have worked for Denmark, but you didn't say why it didn't work. It's still a mystery to me. Whenever this is breached, taken in public, the answer of the Danish government is, we've decided to take the matter to the European level. I do not understand that. If you could shed some light, thank you.
Let's collect, yeah? Yeah. Let's collect some more. There was here, yes, exactly. Yeah, here in front was the second one, at least what I saw.
Thank you very much. I actually want to combine 2 questions together. First, this is not only a European issue, obviously, as we discuss here, but I think the Danish colleague have already said this is happening in Africa, and today we spoke about South Africa. So there are very similar problems in different parts of the world, and in whichever form you find a solution here, it will have a reflection on the other. So whatever standards that we're talking about here globally, we'll have to think that they will apply globally. In that respect, when you discuss about the Fortress Europe, yes, it sounds like that. And, but this is not only about Europe. So can you enlarge a bit your thinking and think how this can apply into the southern hemisphere, for instance, because they're all going to be connected. Second issue is about very practical issue. Like if you're going to have 3,000 people in 2 camps of assessments, the smuggler networks will think that's a very good place to get in queue. So is there a risk of overcrowding this region where they think this is the place to be if you want to get your interviewed? And how is that going to play into the long-term external border protection? Thank you.
And Victoria, please, here.
Thank you very much. My name is Victoria Rietig. I lead the Center for Migration at the German Council on Foreign Relations, a think tank in Berlin. Thanks so much for this very interesting conversation. I have a question about the emergency transit mechanism that Henrik mentioned in one of his answers. And you said, well, the ETM is done already with the help of UNHCR. So if it works for people from Libya, you said, then why wouldn't it work for people from the UK? What's the difference? And the answer, of course, is the difference is consent, which sometimes matters. So the question back to you, to the audience, to the speakers, is in how far does consent of the people who are being transferred actually play a role in the legality of this?
Because I've already have the mic, my name is Vicky Owor. I'm from Kenya Hat. I believe that there needs to be a dialogue between Europe and Africa, but what I see and what I have heard since morning is a monologue. And my question is, if you see Rwanda, it's one of the most less corrupt nations, even better than most of European countries. And what I've heard is that Rwanda is not safe, and you rightfully said if we can do the ETM, why not the other way around? So my question is to you, in terms of Rwanda and other African countries, because Rwanda is already out of the picture, is there any African countries in terms of their judiciary, their legal system, or their human rights system that is good enough for European standard when it comes to save that country?
Thank you. Let's go back to the panel. I think we start with you, Henrik.
Yep. I'll try to.
Was the question about Rwanda, where you mentioned
I think there were
that
5
it
questions
would have
all
worked.
in all, but I'll try to take the first one.
Okay.
Why did we have to stop? Why did we stop? It's a good question, and of course I was holding it back because it's for political reasons. I can't share all the details, but our then government, minority government, was supported by the left wing of parliament. And I think in the most left side of parliament there was opposition, and so the process was slowed down a little bit. And then there was elections 6 months later, and the new constellation, the new coalition government, has a coalition partner, the Moderates, and they are not interested in going solo. They want to move with the EU. So instead of going solo, we ended up with a letter of 15 ministers. And with 4 models that can be pursued in a European context. So it's also a good solution. It's a better solution, to be honest. I think the first road was just to prove to the surroundings that there is a way forward. And now with the EU trying to get together around some interesting new ideas and possibilities, I think we're in a better place. And then the second one was global. It was, how do you think about this in a global context? Well, in an ideal world, regions of the world would care for their own regional issues. I think that would be the first starting point. So anyone in Europe and in a greater Europe context, even neighboring countries to all countries in Europe, I would say that would be my backyard. This would normally be the crowd that I would have to entertain. And also this was how it worked through history. With the globalization, things have changed very much. It's very easy to get from one region to the next, and other factors are pulling people towards these opportunities. And our systems are not very rigid. They're not holding people back. They can actually enter. There is a possibility to pay a smuggler to get in, and you can forge your document. And our external borders are not really strong, and we're really failing in many areas. So there is an opportunity, and it is being used. I mean, it's quite natural. But in an ideal world, I think we should all strengthen our regional capacity to manage our own issues. And I think this is what Rwanda actually said. We will ensure African problems for Africans. And I really think this was meant from the heart of all those very clever people I've met from Rwanda. Interesting enough, it's mostly women who are the top bosses in Rwanda. And they were all very professional. I was quite impressed, I must say, by the standards and the professionalism. And that leads me to the third question. What about the standards of Africa? Are there no standards good enough for Europe? And I totally agree. Of course there are good standards for Africa, and I think there's something wrong with the way we think. Maybe one should go and have a look, and then see what things are happening all over Africa. It's like this is where growth is happening. You just go to Nigeria and in Kenya and Tanzania and have a look. It's a completely new world, So I think we have to review, especially our Supreme Court judges. Maybe they're not moving so much. Maybe they're sitting too much at home. They should go on a study trip to Africa and have a look.
I would
for being so provocative.
Ask both of you to come in, especially I think what it would mean for the global context. If something will come up to you, which question you take in, yeah? Mm-hmm.
I mean, I'm an expert on European law, which is already complex enough. I can tell you it's enough for one academic and professional life. But many here in the room are experts on the more global perspective. And I learned from the discussions here that indeed these repercussions exist. And that's why it would be so important that we do not use safe third countries as a building block for Fortress Europe, which we can be, but that we use them for, well, the roots-based approach to really increase reception, protection capacities, legal pathways for refugees and migrant workers, and that we change the international narrative on migration by focusing not only on asylum from a European perspective, but also on legal migration and protection worldwide. But that will only be achieved, speaking from a European perspective, if we prevent the asylum issues dominating the headline news and elections in the member states. So we must somehow bring order, whatever that means, into the asylum issue. Otherwise, the asylum issue will continue to dominate political thinking about migration in Europe, and the end result will be some sort of external closure. If we do not want that to happen, we have to find reasonable solutions for asylum, which then allow us to move towards a roots-based approach, to legal pathways, to really changing the international narrative. So in a way, if we want to achieve this truly global outlook, it also requires Europe to be able to solve the asylum issue. Very briefly on overcrowding, I mean, that presupposes, I assume, that we would have some extraterritorial EU centers in, let's say, Morocco, Egypt, wherever, where European asylum procedures take place. They could indeed have a, well, pull effect if it is actually easier to apply for asylum because you only have to buy a ticket to Egypt and not pay smugglers to cross the Mediterranean, which costs a lot of money and is very dangerous. So that is correct. That's one of the reasons why this idea, let's prevent the deaths in the Mediterranean or let's solve all the problems by having extraterritorial center is, like everything in this debate, maybe too easy. It's a bit more complex. And thirdly, I mean, I somehow agree with what he said. I mean, from an analytical perspective, speaking as a law professor, the standard we apply in Europe and which we project up on safe third countries are much, much higher than the standards which apply in the rest of the world, including Australia and the United States, which are also part of global outlook, by the way. But that is something which is European, but that's the legal system we have made.
Yes. Damned rule of law preventing us doing all these kind of things. So let me respond to some of these points. Clearly, all countries should build up asylum systems and protection systems. That is the basis of the Refugee Convention and international refugee law. But I think Europe outsourcing its responsibilities does not encourage other countries to build up their protection systems. I have a doubt sometimes about the use of route because it immediately becomes very Eurocentric. All routes seem to end in Europe, and there is a risk that the routes-based approach becomes a way for Europe to justify sending people back down the route. It is possible to build up protection systems elsewhere on a regional basis in terms of local cooperation directly with individual countries, as we heard from Egypt this morning. In terms of any of these issues, there is no one solution. There are multiple solutions. That said, if I was advising politicians now, I don't necessarily want Ekre's advice, but let me give it anyway. The last thing we would suggest is to invest in an expensive external processing model that won't work and that will cost you €1 billion. And then finally, whatever is done, people, refugees, will still need to arrive in Europe to seek protection. So if European states are allowed to deny access to protection for people who arrive, it's really the end of the protection system. There may be ways to limit that, etc., etc. We know the discussions. But implementing the asylum system in Europe at a time when most people arriving do have protection needs. The protection rate at first instance only was 53% last year, with around a third of cases receiving protection on appeal. So some of those people who need protection arrive here will continue to arrive. So getting our own house in order, I think, has to be part of this before seeking to outsource.
Thank you to all three of you. It would be my role to conclude this panel now, but I would like to do this jointly and ask you one more time to take your mobile phone and tell what you think after you heard the discussion also, but of course also what you had in mind before. Would you agree that you should explore models of external processing further? You have 5 options: fully agree, rather disagree, fully disagree, I have no opinion. Okay, interestingly enough, there are not these middle ones with rather agree or rather disagree, but really either fully agree or fully disagree. I think we can, with all right, say we fully disagree on the issue of external processing.
If you add fully agree with rather agree, we win.
Yes, I'm not sure. I can't do the math so quickly, but I will do this in the break afterwards. Nevertheless, big thanks to our 3 panelists that not only provided us some background about external processing. It is in the newspaper every day, but you also tried your best to find common grounds. I very much appreciate that. Above all, I thank you very much for this incredible time discipline, and I would ask for a short applause for our group.